Wesley Robertson versus Kody Gorden. Let me get appearances of counsel.
Good morning, Your Honor. Lisa Rasmussen on behalf of plaintiffs.
Good morning, Your Honor. Rebecca Mastrangelo for the Robertsons as counter defendants.
All right, good morning.
Good morning, Your Honor. Matthew Friedman, 11571 on behalf of defendant Fraser Inouye.
All right, good morning to everyone. So the status check this is a continued or recent status check as scheduled by my order that granted in part and denied in part Mr. Inouye's motion to compel and put fees and costs and related relief. When the status check was originally set, I had contemplated we would talk about whether or not the supplemental discovery or disclosures that I ordered to be produced have been produced, and then how we shall deal with the discovery and case schedule moving forward. So, Mr. Friedman, it was your motion. So let me start with you on status of compliance.
So we have received supplemental disclosures, Judge. We're going through those. I think we got them late last week. And I think the court will note that there was a stipulation we agreed to because counsel understandably was in the midst of trial. And so it needed some time to do that. So we've received them. I can't tell the court at this juncture that we have everything that was ordered, but I can't say we haven't. Candidly, we got them last week and we're going through them. But I did see supplemental responses come through and we're going through those. With respect to, I think the other thing that was on this court's docket was sort of the stage discovery and whether you were going to keep that or not. You indicated if there was an objection to getting rid of sort of stage discovery, you wanted briefing on that. We didn't brief that because I agreed with the court, which was the scope of the case is narrowed significantly. The numbers of litigants in the case is narrowed significantly. So we don't have any objection to the court eliminating stage discovery at this juncture. And my anticipation is that by the end of this week, probably early next, we'll have gone through what we did receive. If there's anything I need to discuss with counsel related to those supplemental responses, I can do so. And, we would be of a mind to just proceed with sort of unrestricted discovery at that point to try and move this case along.
Okay, do you have any objections? So Ms. Rasmussen helpfully filed a proposed discovery schedule. Do you have any objection to her proposed discovery schedule?
I didn't in and of itself. I mean, I think they were just some general dates that were set forth. We've worked pretty well with counsel to date to the extent that I guess anything arose with that schedule, if implemented, and for some reason we hit a snag, I'm sure we would be able to work towards a stipulation around any of those issues. But yeah, nothing jumped off the page to me as problematic.
Okay, let me switch to Ms. Rasmussen.
Thank you, Your Honor. The discovery that was ordered by the court was produced on the date it was due, which was the 12th. The one set was mailed to them on that date, and that was the 7th supplemental, and those were the hard copies of the photos.
Okay.
That were redacted. So
I wasn't arguing it was untimely, counsel. I just was saying it was just that we'd recently received it based on the stipulation. That's all.
I think his comment was that it was late last week, and it was Tuesday.
I meant I got it late last week, not that it was late, last week.
Okay. I said my understanding from our prior conversations was that without all the different parties and with a fairly narrow scope here and two plaintiffs and one defendant, that we probably didn't need the stage discovery anymore, and that was why I proposed the dates that I did. But obviously I would yield to your Honor on how you want to do that. I set a discovery cutoff. I proposed a discovery cutoff that was, I think, September 1 next year.
You did, Friday, September 5th, 2025, okay. Which I have no problem with that discovery cutoff at all. Okay. And it sounds like Mr. Friedman has no objection, and I don't know what Mastrangelo's position is, but I see her shaking her head. Okay. As far as compliance with the order, I have a representation from Ms. Rasmussen that her clients are in compliance with the order and disclosures have been made. I don't have at this point anything from Mr. Friedman telling me that the Robertsons are not in compliance. So anything with regard to the discovery, the supplemental disclosures that were ordered on October 5th, 2024, if there's any issues, Mr. Friedman, the ball is in your court to bring a further motion before this court. Otherwise, I'm going to, if I don't hear anything, I'm going to consider that matter, the matter of the supplemental discovery concluded at this juncture. As far as the case schedule, I'm in agreement with the discovery schedule proposed by Ms. Rasmussen. We'll go ahead and set, I think there was a demand for a jury trial made by somebody in this case, I'm guessing.
I was not the architect of this case,
All right, let's take a
I'm
look,
happy to say.
so that I don't.
I believe it was in the initial complaint filed by the plaintiffs, Judge, but I could be wrong. And then counsel, just so I can clarify for the record, I did use the word late last week. Looking at my calendar, today's the 19th, the 12th was a Tuesday. That's not categorically late last week. I guess it was Tuesday of last week. I was not meaning to infer they were untimely. To clarify that record again, just merely that I had recently received them and we needed to just go through them. And
Okay, so if the only jury demand in this case is the one that was made in the complaint, that is not sufficient under the rules. It has to be made after the filing of the initial pleading under the rules. And so there's a lot of filings on this docket at the beginning. I don't immediately see one.
Your Honor, I don't recall, it's typically my practice to request a jury, but I may not have because I came in a little bit later than, the proceedings were already underway, so I would really have to go check my own records.
I don't see a separate one filed. I'm looking at some of the answers and counterclaims that were filed. I don't see a jury demand and an answer would be fine, but I don't immediately see one. So let me ask this, does somebody want a jury trial in this case?
I need to confer with my client. I suspect if it were to go to trial, we would, and certainly we could update the record with such a demand, but I want to confer with my client to confirm that is his desire as well.
Okay, there is a late appearing filing here. Meaning I am only looking at it now. April 28th, 2023, Michael Stiles did file a separate demand for a jury trial, so that will stand, okay? So it will be, even though Mr. Stiles, I believe, has settled out of the case at this point, I think the demand is still good. And so unless the parties agree otherwise, that demand stands for everyone. We will issue you all an amended scheduling order that sets this matter on a jury trial. How many days do you think you will need for the trial of this matter, Ms. Rasmussen?
5,
Including voir dire?
yes.
Okay. Ms. Mastrangelo?
I'm not sure how the court does the trials. We probably would need close to 5 full days, so if you have a lot of half days, it might go in a little bit farther into the next week.
You usually get 3 3/4 days. I usually start by 10 or 10:30, and then you get 2 full days, and so probably a week and a half then.
To be on the safe side, I think so, maybe
Yes.
5 to 7 days.
All right, Mr. Friedman, how many days do you think?
That seems reasonable and fair with the understanding that you're saying 7 with the 3 3/4 days. And then, I think that's fine, Judge.
All right, so maybe a couple of days, a day and a half or 2 days for voir dire, opening by the end of the second day, and then 5 days for witnesses and evidence. Okay. All right, so we'll set you on we'll just put 7 to 10 right now for ourselves, jury trial. Your jury trial, you will be stacked approximately 6 months from your close of discovery, so that will put you in probably the February or March 2026 stack. That also gives you a little bit of slack with your discovery. Is there anything else the court can do for you at this time? I know I see everyone again on December 6th.
Not at this time.
All right.
No, thank you.
Nothing from me, Judge.
All right, very good. I will see you all in December.
Thank you.
All right, happy Thanksgiving.
Thank you.
Thank you.